let's go over the new final rule for digital accessibility under Title II of the ADA. To start off with, this is a near impossible task. And if you don't believe me, try to create a digital accessibility law that is going to satisfy everyone from all sides. It is a near impossible task. But reading through the regulation, I think the DOJ did a really good job. It's not perfect, it's not exactly what I would have, but the DOJ had to come up with something. And so let's go over their final output, which I have on the whiteboard. Starting with the first block, is they chose WCAG 2.1 AA as the standard for accessibility. I like this path. I like WCAG 2.1 AA. They also apply this standard to web, not only web content, but also mobile apps and documents. So we know with mobile apps and documents, WCAG 2.1 AA does not apply evenly because it is for web content. So there are other standards for PDFs. It's not going to apply perfectly to mobile apps, but they went with one standard because what they wanted to do was keep this simple and not have different standards for different things. So I can understand that route. It will apply evenly, but I think this can be worked through, and I think it's actually, in a way, it will be favorable to the owners of these different digital assets, so of PDFs and apps, because there can be some sort of allowance. There's just something in the in-between aspect of this. But overall, I don't have a problem with this because we're going to bring the same principles forward, the same concepts forward. It's just not going to apply evenly. But I think this will be able to be worked through. There are several exceptions, which are an enormous relief for all of these Title II entities, even if they don't realize it yet. The DOJ did you a tremendous favor by not applying the web content accessibility guidelines to archived content. So any old content that you have, including pre-existing documents that you may house, the DOJ doesn't apply this. So you have up until the deadline, and then you need to make sure that your documents or any active documents that you have are accessible. But as this stands, just imagine going through all of your old city documents or whatever the case is and having to make those accessible. So that's a real help. Also, it doesn't apply to pre-existing social media posts. It doesn't apply to anything posted by a third party. So where a third party posts on your social media or a message board, that's not going to apply. But that really is one of the more minor exceptions, but it was good that they took that into account. Also, this will not apply to password protected individual documents. So for example, like someone's water bill or whatever it is. So that's also helpful. Now, the DOJ did not wholesale incorporate the web content accessibility guidelines. And what they said was there is an exception for minor issues. So if you have a very slight nonconformance with the web content accessibility guidelines, then there's an affordance. What's difficult is when is there going to be a minor issue and what is not considered a minor issue. So it's going to depend on whether something is an outright barrier to access. We just don't know at what point this would be. And this is where I think there will be some deviation when we have Title III, because what are minor issues? And I think it's good that the DOJ started with Title II, because the Title II entities are much less likely to be targeted in the litigation, the private litigation that we are seeing now. So it's good that the DOJ started here and they can build off of this for Title III. They will need to make some changes, and they will need to account for the private litigation that is happening in Title III when they come out with Title III regulation. But as it stands now, we didn't see the wholesale incorporation. We saw the allowance for minor issues, but in practice, how does this play out? So that's a question. We also saw, this is what is especially nice for all of these state and local government entities, is you either have 2 years or 3 years for compliance. This is another huge relief. So the DOJ being realistic about the timeline here and the expectations and the cost. So this will allow you to budget for accessibility, and it will give you the time necessary to train your digital teams, to go out and procure services, etc. So I think they made the right move in allowing 2 or 3 years, knowing that, this gives you the ability to start working on accessibility now. So you're already going to improve accessibility, and then you have until this deadline for compliance. So the DOJ did a lot of favors. They really benefited the Title II and Title III entities with the different exceptions, and then the 2 or 3 years. So my recommendations: start right now. If you start right now, this is going to be much easier than if you wait. The longer you wait, even though it's not in your current budget or whatever the case is, the longer you wait, the more difficult you will make this on yourself. I promise you that. So if you start right now and you start working on the easier accessibility issues, you start training your team on the web content accessibility guidelines, and really everyone who is posting content, whether it's social media content or whether they're working on your website or they were working on your blog, etc. If these people are working on your digital assets, you want to make sure that they are being trained on the web content accessibility guidelines. You want to make sure that you are incorporating accessibility into your processes now, so that on the date of compliance, on the deadline for compliance, you're already there. And this is something that you've already been transitioning to this whole time, because the transition will take a while. It is very important that I can't stress enough that you should start right now. I have the WCAG course available, and with this WCAG course, you'll not only get explanations for the web content accessibility guidelines. I've also divided the web content accessibility guidelines 2.1 AA into the different roles for your team. So there are workflows for the web designers, the content editors, and the web developers. This will be very important. And whether or not you're using contractors or you have your own people in-house that are working on the digital assets, this is something to learn about now and start working on now, because you not only have to learn this, but you have to incorporate it going forward. So then I have here the deferment of costs. So you can start with an audit now, know all of the accessibility issues that exist, and then get a remediation later and help divide up these costs. And for an audit and remediation for one website, you're typically looking at between $5,000 and $7,000. It's really going to depend on the website. But keep in mind, this doesn't make it the Title II final rule did not take into account, let's say, the first 15 pages of a website versus an entire website. So even with an audit, you're just going to have the first 15, 20 pages, all those unique layouts, and then you're going to apply those changes to the rest of your website, which are likely very similar to what is in scope. So knowing that, work from the audit, preserve the audit's freshness by not making major changes to the website after the audit. And then if you need to defer the cost, then hire someone for remediation later. But again, start now. All right, so what did I like and dislike about this final rule? Well, I dislike the wholesale incorporation, because in practice, it makes it very difficult for an entity to be fully WCAG conformant. So there are just some issues that are going to take a while to get through. And one reason I recommended training for the web content accessibility guidelines is this allows you to better procure services, because your team will know exactly what they need. So if you learn about web accessibility, then you learn what you need for web accessibility. So I dislike the wholesale incorporation. They did make this slight affordance, though, with the minor issues. So there is a little. It wasn't an entire wholesale corporation. I also disliked the fact that they applied the web content accessibility guidelines to apps and documents, because that's not the web accessibility for web content is different from that of accessibility for native mobile apps and documents. So there is going to be some unevenness there, but I understand why they kept everything simple. They didn't want people to be going back and forth through standards. But that is also something I disliked. But then also I did, as I mentioned, I like that the fact that they considered minor issues. I really like the fact that they provided all of these exceptions, especially for old documents. That tells you the DOJ was being realistic, and they know that it's going to be an impossible cost to make all of these old documents, many of which are not even being used. It's just impossible to make all of those accessible. It would literally be millions of dollars, because there are some entities with just thousands and thousands of PDFs which are inaccessible, and to make those accessible, it's just an impossible cost. So that was realistic and practical by the DOJ. And then also with 2 or 3 years, this was a really good um, a good allowance by the DOJ. The DOJ did a really good job with 2 or 3 years. This is realistic. This is something that allows these different entities to comfortably work towards conformance, and give them enough time to where, if they have a bigger website, or then they can work towards full conformance, or they could start limiting the pages. So taking out unnecessary pages. What do people visit? What do they don't? That was really good. That was a really good addition by the DOJ. So overall, I think the DOJ did a good job. If I'm going to give out a letter grade, it's going to be a B. They kept this simple, straightforward, and this gives them something to build off of for Title III. I think we will see more detail in Title III. As it stands, the Title II rule, if we apply this ultra litigious legal landscape, it would create a lot of difficulty. But as it is right now, I like what they came out with, in the sense that they kept it simple. It was always going to be an imperfect task. You're never going to make everyone happy with this, but I think they did a really good job overall. So if you need help with consultation or services, I offer those through accessible.org. And then I also offer training through adacompliance.net. I highly recommend my WCAG course, available at adacompliance.net. This will train you on the web content accessibility guidelines. And as I mentioned, the standards are WCAG 2.1 AA. Those standards, I cover all of the success criteria for WCAG 2.1 AA. So I will leave those links in the description.